Good morning, everybody. Welcome to the Bond, Schoeneck and King Winter Special Education Webinar. This webinar is titled The ABCs of Special Education, 26 Keys to Meeting Your District's Legal Obligations. We're going to have some fun this morning, going over some important topics. We're here with our wonderful panel, myself, Jeffrey Weiss, an attorney partner in the Buffalo office, Dr. Ann McGinnis, attorney partner in the Rochester office, attorney Andrew Mark in the Buffalo office, and attorney Catherine Stifler in the Rochester office. We're here today. A couple of ground rules. We're going to go over 26 topics, things your district needs to know to ensure that they're in compliance with special education. After this program, you'll be sent a link with the recording and the slides. And if you have some questions, you can pop them in the Q&A, and we'll do our best to get to them. But we really have a lot to cover. We have 90 minutes, and we have 26 topics. So it's going to be rapid fire. And it's going to be loose, and it's going to be fun, and we're going to give you some good information that you need, because there's a lot of rules out there in special education, and half the challenge is keeping track of them. If you don't know the rule, you're not going to comply with the rules. So that's what we're here today for. So let's get started with A. I feel like this is a throwback to Mr. Rogers and Sesame Street. It's A, age of majority. This is an issue comes up all the time, which is a simple one. Get a call and they'll say, what happens when the student turns 18? The student has an IEP. What happens? Well, we actually have a clear-cut answer for what happens. Now, for context, in the federal statute, the IDEA says that it's up to the states. And the states can decide on a state-by-state basis how to handle this. So it's possible that in some states, the parental rights will shift. Decision-making rights will shift from the parent to the student when the student turns 18. That's possible. But in New York, they have not selected that option. So in essence, with respect to CSE decision-making rights, nothing changes when the parent turns 18. You can get some weird situations with this because you could have an adult student essentially saying, I don't want an evaluation, I don't want the service. But in reality, the decision maker remains the parent in New York. So on the next slide, we should realize, though, there is one right that does shift, sort of. It's not the CSE, special education decision-making right. It's the FERPA right to student records. That right, transfers to a student on 18. So when a student is 18, the student can request copies of records and so on. That right remains, however, with parents of students with disabilities under the IDEA. So with respect to accessing records, both the parent and the student have that right, but the decision-making right, consent, standing to seek submit an impartial hearing request, that stays with the student. Okay, next slide.
Good morning, everybody. I'm going to be sharing some information about behavior intervention plans, also called BIPs. These are supportive plans for students that are developed after a functional behavioral assessment is conducted, and it supports a student's behaviors by reinforcing replacement behaviors to address the problem behaviors that the students are demonstrating in school. Next slide, please. There are certain times under the regulations that we're required to implement a behavior intervention plan. One is if the student exhibits persistent behaviors that impede the student's learning or the learning of others. Two is if the student's behavior places the student or others at risk of harm or injury. Three is if the CSE or CPSE is considering a more restrictive program or placement as a result of the student's behavior. And then four is if we're considering either a long-term suspension or a suspension that accumulates to more than 10 days, non-consecutive days in a school year. And the most recent reasons is a pattern. Both of those situations require a manifestation determination. If we go to a manifestation determination, and if we find a connection between the student's disability and the misconduct, we're required to implement a BIP. There's other circumstances where the CSE may determine that it's appropriate to implement a BIP, even if it's not one of these, and that's fine. But these situations are when a BIP is required. Probably one of the most important scenarios that I see is making sure that we implement a BIP before recommending a more restrictive placement for a student with behavioral needs. The regulations don't say how long we need to implement that BIP before we can recommend something more supportive for the student, but they do say that we need to implement that BIP. It probably depends on the circumstances. I would say at a minimum, at least one iteration of data collection on the effectiveness of that BIP. But it is very risky to place a student in something more restrictive due to their behaviors without first implementing the BIP. There have been cases that have found that that alone is a reason to find that the outside placement is not appropriate for the student if parents initiate due process. Next slide, please.
Good morning, everybody. As Jeff said, I'm Andrew. Happy to be here with you this morning. I'm going to talk about a big one. C is not for cookie. C is for consent. That's a Sesame Street throwback. Oh, maybe you got young kids out there, but anyway. So consent is a big one when it comes to, we're talking about two things here, really, evaluations and services. So we'll break these down. Parental consent, of course, is required for an initial CSE evaluation and subsequent reevaluations. We know this, consent also, of course, must be informed. What does that mean? All relevant information about the activity for which you're seeking consent has been explained in the parent's native language, if applicable. It means the parents agreed in a writing that describes what the consent is being asked for. That's our PWN. And then they understand that it's voluntary and can be revoked. So you need consent for an initial CSE and subsequent reevaluations. Now, for an initial evaluation, if the parent does not provide consent for that initial, there is a process in the regs that you can override that refusal to provide consent, and you can pursue a due process hearing to override the parent. I think that's pretty rare, but it can be done. So now when a reevaluation is, when we're talking about reevaluations, that process is also there. You can pursue that, but it's a strange rule, but parental consent is not strictly required for a reevaluation as long as you can demonstrate that you took reasonable measures to obtain that consent, but the parent failed to respond. Now, if the parent responds and says no, that's not what we're talking about here. That's a stop. I'm not giving consent. But if you reach out multiple times and you don't get a response, that might be a scenario in which you can move forward with the reevaluation. Now, like I said, if the parent says no, there's still the possibility that you could initiate due process to override consent, but you don't have to. How many steps are we talking about? Well, certainly one is probably not going to be sufficient. Maybe two is not sufficient. Maybe three is not sufficient. It really kind of depends. That's where you want to, get in touch with us to talk about what the facts are. But just know that, for a reevaluation, consent is not always strictly required, but obviously the best practice and best case scenarios if we get it. Now, for services, parental consent is required for the initial provision of special education services also. Now, unlike evaluations, if the parent does not provide consent for the initial provision of services, you cannot attempt to override that through due process. If they go through the evaluation process, you ask for consent to initiate implement the initial IEP, the parent says no, that's it. You can't initiate due process. Now, that's for initial provision of special education services. You do not need legally, do not require consent, for a change of placement or to implement a subsequent IEP. Now, from a practical standpoint, if the parent disagrees, they can initiate due process, and that's how they can, they have their input in that way. But you do not need consent going forward after the initial provision of special ed services.
Andrew, can I just say something quick, if it's okay, to add?
Sure.
For a little known rule? So we know that you need consent for an initial evaluation. So the timeline for an initial evaluation starts upon receipt of the parent's consent to evaluate. Since you theoretically don't always need consent for a reeval, the timeline is different than an initial consent. It's based on something called like when the request for review is made, which nobody knows what that means, to be honest. I think it means like when they propose the eval, but nobody knows for certain. So that's a really strange area in the law where the timeline for the reeval is not entirely clear because nobody knows what's really initiating it. A little topic at your next dinner party. Oh, Andrew has a question. If a parent declines testing, how do we move through determining whether or not they still qualify for services? Do we just continue services? So this must be a reeval. If you have time for a reeval, and they don't let you do a reeval, what do?
I think you could do a records review. That's one possibility. You don't need consent to do a records review. If they don't let you do the testing, so are we talking about a scenario where you've requested consent to do a reevaluation? They said no.
Yeah, right.
So the records review is one possibility. The other possibility is, you could initiate due process.
Right. You essentially have to do what you can with what you have,
right.
But you don't want to. I think, Anne, would you say you don't automatically declassify on the spot, right? That would be
No, I wouldn't automatically declassify or automatically continue. I
Yeah.
would consider the information we have. The student's progress toward their IEP goals is going to be a really important piece of information on that, together with any progress monitoring or assessment information we have from the curriculum. A parent can't essentially prevent us from declassifying if a student isn't entitled to services anymore, but we have to be careful to make sure that we still have sufficient information to justify the declassification.
Yep. All right, Katie.
All right, good morning. So I am going to be talking about data or data, no matter how you pronounce it, it is important to us. So the world of special education is very data-driven. For a student's special ed program to be deemed appropriate for them, as we know, it has to be reasonably calculated to enable that student to make appropriate progress in light of their disability and their circumstances. So part of how we do that is we collect data in order to prove that the student is making an appropriate level of progress in their special ed program and services. So districts want to make sure that they have processes in place to track and monitor student progress by collecting timely and accurate data throughout the school year. So part of this includes drafting those measurable annual goals. We want to make sure that those are easily tracked. So we're going to track those pursuant to the frequency that we have in the IEP. And then because we've put in all that work to write these really clear annual goals, we want to make sure that we're monitoring the students' progress toward those goals by collecting data. And one of the reasons that data collection is very important is because without data showing that the student is making progress, it can be really difficult to prove that that student is in an appropriate program and that the district has provided that student a free, appropriate public education. So we want to make sure that we are creating clearly measurable annual goals. And then not only that, but that we are consistently collecting data so that if we go to due process, we can show this is the data that we're collecting. This is how the student was making progress in their program.
Okay. Extended school year, ESY. So the goal of extended school year is simple. It's to prevent substantial regression. Now, and we're really talking about over 2 months, over July and August. The goal here is how do we know if we need ESY? Well, we have to figure out, does the student lose skill, a set of competencies and knowledge during the month of July and August? Now all students lose skill over those 2 months because they're not in school. So is every student who regresses entitled to extended school year? No, it's got to be substantial regression. And so what you're really looking at is, I think the concept here is every student is going to fall behind a little bit over the summer, and then they're going to catch up when they return to school. And it's going to take them a certain amount of time to catch up. Kind of just like an athlete didn't play in the off season, and they first step on the court or the field, they're not going to be as good as they were at the end of last year. But after a couple of practices, they should be just as good. So the question is, will the student need more time or beyond the time ordinarily reserved for that purpose at the beginning of the school year? This is hard to figure out. So here's something really helpful. We know that the typical period of review or reteaching ranges between 20 and 40 days, which is essentially 2 months, 1 to 2 months. November. By November, you're going to be caught up. Thus, if it's going to take you more than 8 weeks to catch up to where you were at the end of the previous year, that would be substantial regression. So that's what the CSE has to figure out. Now, it's hard to do that because the best you could do is, well, you could look at how you did the previous summer. Now that's a better indicator because you're coming off 2 months. You could also look at how you're coming out of a 1 week break or a 2 week break. And that's helpful. I don't think it's necessarily the same thing, but it's certainly relevant. But based on all this information, you're going to have to figure out if the student is, likely to substantially regress. There's some guesswork there. And you have to do your best with what information you have. And ideally, again, going back to data, do you have data from the previous year? Did you do testing in September, October, November? Was the students still lower than you'd expect in November, but maybe caught up in December or January? That's going to be helpful. So again, data is there. Now, the severity of the disability is also relevant too. That's where the expertise of the educators come in to say, I know a student with this profile is probably going to need extra time to catch up. So it's a big judgment call, but there's a strange rule also. There's a definition in the regs that says if we think you're going to substantially regress, you get ESY. But then there's another rule that says this is what ESY shall be considered for students with highly intensive management needs. And that means students in 611, 811, and 1213 special classes. and for students who require residential programming. So what does that mean? Does it mean that students in 611, 811, 1213 in residential are automatically entitled to ESY? No, that's not what it says. However, clearly, this group of students is at a higher risk of needing ESY. Now, the way I view it, and again, there's no case law on this, I would view it as students in 611, 811, 1213 in residential, I would presume they need ESY and let the data show that they don't. I don't know how you're going to prove that if they've been getting it all along or so on. That's just me. But clearly, these kids have been identified in the regs as a higher risk, and we can't ignore that. And if we're going to not give them ESY, we should be ready to defend our decision. Okay, on to the next one.
Functional behavioral assessments. So it would have made more sense to talk about this before BIPs, but F comes after B. So here we are. So if you'll remember when I was talking about when we have to put a BIP in place in situations like if the student's behavior impedes the student's learning or the learning of others, or if the student is a safety concern, if we're considering a more restrictive placement, if a connection is found at manifest. Obviously, we have to do a functional behavioral assessment when we have suspicions of any of those things happening, because that is the first step to determining if a student requires a BIP. So a functional behavioral assessment gathers data about the problem behavior, the antecedents that precede that problem behavior, the consequences after that problem behavior happens, and that helps us determine what the function of the behavior is. Every child's behavior is serving a need for that child. So if we can identify why this problem behavior is serving that need, we can find a way to fulfill that need, and another way to reinforce the child demonstrating a replacement behavior. And that's what the FBA is designed to assist the CSE with determining. So the first step is conducting the functional behavioral assessment. Then it goes to the CSE, who reviews the functional behavioral assessment and determines if the child requires a behavior intervention plan. There are a lot of legal requirements for what has to go into an FBA. I find that frequently FBAs may be clinically appropriate, but they might not be legally sufficient. And case law has expanded what has to go into an FBA. So it's not sufficient to just look at the regulations that have the requirements. We do need to include everything in the regulations that describe what has to go into an FBA, but some other requirements have emerged through case law that also need to go in there. And there have been cases where deficient FBA has been a reason that a hearing officer has determined that a district has failed to offer free appropriate public education to a student, meaning districts have lost cases just on deficient FBAs alone. And that would be a procedural violation that could arguably turn into a substantive violation. So we can avoid that by having a really good FBA template that complies with the law to assist our teams with ensuring that all of those required components are in there so that it's both legally sufficient and also clinically sufficient. Next slide, please.
And actually, we had a good question. Someone asked about ESY. What do you do if you've been giving a student ESY all along? How could you determine that they don't need it anymore? And that is a great question. I think is just off. I think one way to do it is to wean the student off it, maybe give less and less each year and show that there's no regression. That would take a while. The other is to look at after shorter breaks. But I think I would say that's kind of risky. And again, I think of if you cut it down 1 year to the next, and you're not seeing the regression, you might have a shot at defending that. Any thoughts on that?
Sure. I think the more data we have to make decisions, the more defensible any decision we make is, including an ESY decision. So I've had hearing requests where parents have said, how do you know my child doesn't need ESY? You haven't taken regression data. That's hard to defend if we haven't taken that regression data. So If we have really, and I find that teams are frequently confused about how to take regression data and need some guidance and training around that as well. Because it's based on an already mastered skill, not a skill the student's currently working on, and it's based on how long it takes the student to regain that skill with explicit instruction after returning from a break. So there's a few different components to that. And if you have the data to demonstrate there is no substantial regression, then it's probably defensible. If you're looking to collaborate with the parents, which we always should try to do if we can, the idea that Jeff had, which is slowly reducing to show the child is doing well, there's no harm in doing it that way either. Best way to do an FBA for a student whose behavior that is impeding their education is lack of attendance at school. Yeah, I mean, the best way to do it is to go in the home and take data. Some districts do that, most don't. But home is the antecedent there. Can we set up the parents to take some data for us? Can we send a team there in the mornings to figure out what's going on, especially if it's like a school avoidance situation where a student's anxiety is preventing them from coming to school? There are different types of functions of behavior for school avoidance. So to really put a strong BIP in place, we need to know what that function is and to take data around that. If we're not able to go in the home and take the data or set up data collection with the parents, we have to do the best we can. But it's unlikely that that FBA would be considered sufficient if the parents were to initiate due process. And this is a situation where parents initiate due process a lot when kids are unable to come to school because of their disability. So we have to be really careful in those situations. Probably a good idea for a consult.
Right.
All right. Okay, gifted and talented students. Gee. So this is a little counterintuitive, you might think at first glance. If we're talking about gifted and talented students, it might be counterintuitive to, and imagine a scenario where they could require special education, but it's certainly possible. So they can be, gifted and talented students can be eligible for classification as a student as long as they meet a student with a disability, if they meet the eligibility requirements for an IEP. If we skip down to the third bullet point, it's not as difficult to imagine a scenario where you have a student with a very high IQ, high intellectual ability, but they could still be classified and come in on other grounds like ADHD or autism. They have an emotional disability or hearing or speech related needs. The other way that they can come in, and one that's sort of been disfavored, for some time, is the harder question is if we determine if we classification under learning disability, or if to determine if they're learning disabled. So we know that in the case of like K-4 students for reading, for example, we can't use the severe discrepancy standard to determine if they have a learning disability in reading. Now, for gifted and talented students, that's where their giftedness could come into play. So let's say, for example, you have someone with a very high IQ, but they're achieving in the average, say low average range. Normally we would not, take a look at the discrepancy, between their intellectual ability and their achievement. But in the case of gifted and talented kids, that does come into play. Now, I'm not saying that overrides the regulations for the K-4. I'm just talking about, just in general. So now that doesn't, like, if there's a severe discrepancy, and you kind of have to decide, what should they be? Is there a discrepancy between if they're a student with a really high IQ and they're achieving 99s, and they should they be achieving 100s? I don't know if that would be a severe discrepancy. So, but maybe they're achieving in the 75 range, but we know they're, according to their IQ, they could be doing much, much higher. That's relevant. Now, that doesn't automatically mean that they're entitled if there's a severe discrepancy between their intellectual ability and their achievement. There could be other reasons, why their performance is low. Maybe they're just not doing homework or something like that. That would go against classification. But the point is, it's not the no-no that it is in normal circumstances to use the severe discrepancy standard when it comes to gifted and talented students. You know, and if they are eligible for an IEP, that's they're considered twice exceptional. Just in one other point, gifted and talented education is not special education. There's no entitlement to gifted and talented education. This is not special education. Well, gifted and talented education is not special education in and of itself, but those students can be eligible for an IEP if they meet classification criteria.
I wonder if there's a significant discrepancy, but the student's achievement is still in the average range. Would that student need an IEP? Is there a need for special education? That's something for, and we see that with our gifted students. They may have an IQ, a full scale IQ of 132, and achieving in the average range around 100. That's 2 standard deviations. That's likely a significant discrepancy, but would that require a need for special ed? That's something for the CSE to consider. Parents sometimes ask for an IEP to address gifted needs in addition to the student's disability. We have no obligation to do that. And I think that that can blur the lines of what an IEP is in New York State. There may be differences in other states, but that's how it is in New York State.
Yeah, and another interesting aspect of this is, you know, the legal standard for a FAPE, you know, is appropriate progress in light of the child's circumstances. So what are the child's circumstances that they're gifted? On the other hand, there's, you know, that rule hasn't overturned the case law that says you're not required to maximize a student's potential. So finding that line of where the FAPE is I think probably challenging too. I think this is rare. I don't know. This certainly hasn't come up for me at a due process hearing, but that would be interesting and probably not very fun to have to defend.
All right. H is for home and hospital instruction, and requests for home, hospital, and institutional instruction under 100.22. We're seeing more and more of those requests. So we're going to talk about sort of the 2 different pathways through which a student who is classified can be placed on home instruction. So first, home and hospital instruction is an option on the special ed continuum. So that means that the CSE has jurisdiction and the authority to place a student on home instruction if the CSE determines that the student has a disability-related need to be on home and hospital instruction. So as a result, students with IEPs can be placed on home instruction through 2 sort of possible paths. The first is the one that we just talked about, which is that the CSE can place the student on home instruction as a placement on the special ed continuum. And the other pathway is that the district can place the student on home instruction, and this is pursuant to Part 100 of the regs, specifically 100.22 and 175.21. All right, so what does that regulation say? So it says the general education option for home instruction. So this is when the district receives a request from the parent for home instruction, and the parent's request has to include the following. It has to have written verification from the student's treating healthcare provider, which can include a mental health provider, demonstrating that the student is anticipated to be unable to attend school in person for at least 10 days during the next 3 months. So that's the first part that the request has to include. Then it also has to include a signed consent that authorizes the district's medical director or their designee to contact that student's treating healthcare provider. And this is a really key part, because if the district doesn't receive that consent for the medical director to talk to the student's treating healthcare provider, then that is going to result in an automatic denial of the parent's request under Part 100. So parents' written request for home instruction has to include both written verification from the student's provider indicating that the student is anticipated to be unable to attend school for at least 10 days in the upcoming 3 months, as well as that signed consent authorizing the district's medical director to contact the student's treating healthcare provider. So to the extent that the CSE has the jurisdiction to place a student on home instruction, Part 200 doesn't expressly include a corresponding requirement for a parent to provide the district with the same signed consent that it does under Part 100.22. But under both the CSE and the gen ed options for home instruction, the following minimum requirements apply. So if we have a student who is at the elementary school level, we have to make sure that we are providing minimum 10 hours of instruction per week. And to the extent that it's possible, we want to be providing at least 2 hours of daily instruction if we can. For a student who's at the secondary level, that minimum hours of instruction goes up from 10 to 15. And again, to the extent that it's possible, we want to be providing at least 3 hours of that daily instruction. Important to note that students can receive less than that required amount of instruction, but it needs to be supported by documentation that has been submitted by their treating healthcare provider. So we might have a situation where pursuant to the opinion of the treating healthcare provider, the student is unable to engage in that level of instruction per week because of maybe their medical condition or for another reason. So if we have that documentation from the healthcare provider, we can provide less than those hours of instruction. But otherwise, for students at the elementary level, it needs to be minimum 10 hours per week, and at the secondary level, minimum of 15 hours per week.
Okay, we're up to I. I is for independent educational evaluation. I'm always amazed what a powerful right this is for parents in the process. So a parent of a student with an IEP has the right to request an IEE following the district's evaluation of their child. So district does its evaluation first, parent disagrees, they could request an independent evaluation to be paid for by the district. Also, if we don't class it's not just parents of students with IEPs. It also covers parents of students who were suspected. So if you did an initial evaluation, initial referral, the district evaluated, student was not found eligible, the parent could still request an IEE, and after that, we refer the student back to the CSE. So if a parent requests an IEE, the district will have two options. Option one, grant the request. We'll say, sure, we agree to pay for your independent evaluation. The other option is to say no. But if you're going to say no, you have to initiate an impartial hearing to defend the decision that the evaluation is appropriate. So most evaluations, that's going to be our defense. There might be circumstances when we, actually, let's go to the next slide. The district may challenge the parent's request on various grounds. Okay, the most common is to say, hey, our evaluation was appropriate. There's no need for you to go to an independent. But there are other grounds on which we could object. We could say the independent evaluator is unqualified. We could say the cost of the proposed evaluation exceeds the competitive rate of an evaluation within the area, or we could say that the proposed evaluator is located outside the geographic parameters of the district. To do that, you really want to have a great IEE policy that sets forth these are the requirements for an evaluator. These are the qualification requirements for an independent evaluator. These are the costs in our area. This is the area geographically within which we think you could find an appropriate evaluator. So we could initiate. Now we could object on those grounds. Now there's emerging guidance that says you don't necessarily need to initiate a hearing when you're going to deny a request, an IEE on non-substantive grounds like the qualifications, geographic area, and so on. The problem with that guidance is there's many jurisdictions that consider IEE response. It could be a court, it could be a hearing officer, could be the SRO, it could be CEQA, and they don't all follow the same rules. So if you ever don't initiate a hearing, there's some risk in waiving. But again, the tide is turning. But the problem in special ed is there's so many decision makers, and they tend to follow their own rules. But again,
I've had CEQA consistently for at least 10 years say that if a parent chooses an evaluator who doesn't meet our criteria, our only option is to pay or initiate due process.
Yep.
And I've actually had a situation where we received that decision from CEQA, so we initiated due process and the hearing officer dismissed it and said we waited too long. I don't think that was the right decision, but it just gives you an idea of what districts are facing. It's very risky to just say no without initiating due process.
Yep.
There's also more case law coming out now in New York State saying that parents are entitled to IEEs even in areas that the district has not already evaluated. So that's a change as well. It used to be if we hadn't evaluated in that area, we could say we need to assess in there first. But there was a guidance document from the Federal Education Department, letter to BOUS, that came out more than 10 years ago now, that said parents could be entitled to an IEE even in an area that the district has not yet assessed. In New York State, we did not adopt that, but I have seen SRO decisions at the state level that have adopted that more recently.
So it's rough out there.
It's rough out there. IEEs are
land.
rough, guys. Yeah, you're getting clobbered with them. I know that. Yeah. Okay, jurisdiction of CSE subcommittees. So we can have full committees on special education and we can have subcommittees on special education. A full committee can do anything that a CSE can do. A subcommittee can do just about anything that a full committee can do, except when considering a student's, considering a student's initial placement in a special class outside the student's school of attendance, or a school primarily serving students with disabilities, or a school outside of the student's district. So if it's the first time we're considering that for a student, it has to be a full CSE committee. If we have a subcommittee meeting, a parent can submit a request for a full meeting. From a practical perspective, I don't really see why we would differentiate these days. I think it's okay to just call them all full committees, but some districts still have subcommittees, and that's certainly permissible to do that. Especially if you have a bigger district, that might be a reason to have a subcommittee. But just be aware of those differences. Also, some differences in attendees, depending on the circumstances. A school psychologist is only needed in certain circumstances for both. But yeah. Okay, next slide.
Okay, excuse me. Kindergarten age students who are not enrolled in school. So this does come up from time to time. This is a unique group of kids under the regs. So these are students eligible to attend kindergarten, but they're not yet compulsory school age. So they're not enrolled in school. So let's flesh that out just a little bit more. So these are students who have aged out of CPSE. They're not parentally placed. They're not being homeschooled. They're eligible to enroll in kindergarten, but they're not enrolled, because they're not, they're not compulsory age. They don't have to be. So these students are within the jurisdiction of the CSE, not the CPSE. They've aged out of CPSE jurisdiction. So they're entitled to an IEP, not an IESP. So under normal circumstances, if a student is, homeschooled, for example, they might, they could be eligible for an IESP, a services plan, but they're not, in this case, it's an IEP. Now, the interesting thing about this is the IEP generally will only include services. So that would be, related services and perhaps tutoring instruction. The rules aren't really, clear about, what to do there. But they're not going to be placed in a program like a special class. They're not enrolled in school, so they're not going to be placed in a program. So, the IEP, they're entitled to an IEP, generally going to be, services only, and the district of residence determines the location that the services will be provided. Now, one other interesting thing, there is a guidance memo on this. So there's a link at the bottom of this slide. So this, there's a guidance memo on SED's website. And one other thing, these children are, according to the guidance, deemed enrolled for the purposes of claiming state aid. So they're deemed enrolled in school for state aid purposes, but they're entitled to an IEP. So the guidance says you have to offer an IEP to these folks, to these students.
And one interesting thing is that kids who are not immunized, sometimes, when you're not immunized and you're compulsory school age, you can't enroll. You have to have an IESP. But this group, since they're not enrolled, they can they can claim entitlement to services for this short period of time, and we would have to provide the services outside of the school, even though we generally can determine the location. So it's sometimes the kids who maybe they're at the preschool level and they're not immunized, and that's certain rules for them. And then once they get to an IEP age compulsory, they can't enroll and they have to get an IESP. But these kids are different and they fall under this unique group. And I'm seeing more and more kids, since immunization is becoming less popular, they're using this as an option to get services during this time period.
Okay, L is for the way you look at your special ed legal obligations, okay? But it's also least restrictive environment. So the least restrictive environment is one of the bedrock principles in the CSE process. So the CSE has to place the student in the least restrictive environment that is also an appropriate placement for that student. As a result, the CSE should not place a student in a more restrictive educational setting. For example, moving a student from a mainstreamed gen ed classroom to an 811 special class, unless the CSE has determined that there are no other supplementary aids and services that will enable the student to make reasonable progress in light of their circumstances in that current setting. So it's important to note that over the years, there have been considerable technological, educational, and behavioral advancements, which have, in a lot of instances, extended the timeline for the district to exhaust all of those potentially appropriate supplementary aids and services before appropriately placing the student in a more restrictive setting. So before we're looking at moving a student to a more restrictive setting, we want to be able to demonstrate that we have exhausted all supplementary aids and services within that student's current setting, that those aren't working, and that a more restrictive placement is appropriate for that student.
Okay. On to M, mediation. We can move back one slide, please. That would be great. Thank you. M, I keep thinking M is for cookie, even though that's going way back. M is for mediation. Parents of students with disabilities have the right to request special education mediation at any time. You don't need a hearing request pending to request mediation, but you can request mediation in lieu of a resolution session. So you have some options. There is no cost to the parent to participate in the mediation process. I don't think there's a cost to the district either. Upon receipt of a special education a request for special education mediation, the district must contact the Special Education Dispute Resolution Center to schedule the mediation session. You call them up, you give the information, the name of the parent, contact info, and they handle all the scheduling. It could be done in person, it could be done remotely. Sometimes you have to wait a couple of months for this to get scheduled. Sometimes it's a couple of weeks, it depends, but they handle all the scheduling. Now, here's a tip to show that you know what you're talking about. When we receive a request for special education mediation, the district must send the parent a copy of NYSED's 47-page procedural safeguards notice. By the way, the same requirement exists when you receive a CEQA complaint, a NICED Special Education Quality Assurance Unit complaint. When you get one of those complaints, you got to send the parent procedural safeguards notice. Shows you know the rules. Now, at the mediation, discussions at mediation are confidential by law, by rule. No one could use what you say outside of the mediation process. In contrast, resolution sessions are technically not confidential, although I like to ask the other attorney to agree that it's confidential, because how are you going to have a free flow of ideas, negotiations, if it's not? And then lastly, the district has the right to attend the mediation session with counsel, even if the parent is not represented by counsel. There's this rule for resolution sessions that could prohibit the district's attorney from attending. The parent doesn't have an attorney. That rule does not extend to resolution to mediation, although sometimes a parent will complain that they don't want the district's attorney there because they're intimidated. It's up to the district to decide what to do. It's your right. And look, mediation, I'll be honest, I've had some good success over the years with mediation. The mediators are helpful. I think the attorney present, when the attorney's present, the mediator actually welcomes that when we're being collaborative and helpful. So if you get a request for mediation, try to look at it as an opportunity to improve a situation. It shouldn't get worse for mediation, so maybe you'll get some luck. And usually, I more than half the time, I'd say we resolve the matter through mediation.
All right, this is a big one. Our duty to accommodate students for non-academic activities. This is something that I find a lot of districts are surprised about. So under Section 504 law, regardless of if the student has an IEP or a Section 504 plan, we are obligated to accommodate students for non-academic activities so that they can participate in the same manner as their general education peers. So some non-academic activities where this would apply are things like field trips, class trips, overnight trips, school dances. It could even be any kind of club, sports, any athletics that are offered by the district, anything that the district offers. We are required to provide a student with a disability the accommodations they need to be able to participate in the same manner as their general education peers at no extra cost to the parents. There's also situations where maybe it doesn't seem on its face like it's a district activity, but we're still required to accommodate. So things like running a summer camp at the district, things like running an after-school daycare or childcare program or before-school childcare program at the district, something like the PTA coming in and running an event. It's possible that the district would still be required to accommodate, even if it's not on its face a district activity. That depends on the circumstances, and that goes a little beyond what we're talking about today, but I just want you to know that it's still possible that we have to accommodate, even if, for example, the PTA is coming in and running it. It depends on the factors of how involved the district is and a variety of other factors. The accommodations that we need to provide would typically be identified by the CSE or the 504 team. It's a good idea to be proactive about this and to not be like, oh, shoot, they're leaving in 4 hours for a 4-night trip to Washington, D.C., and this student might need an aid. What do we do? It's better to have that conversation months in advance and decide if the student does need an aid for that trip. Not every child with an aid on their IEP would automatically need an aid for an overnight trip. It depends on why the child has the aid and what the activities are on the trip. Maybe there's a circumstance where a child does not have an aid on their IEP, but they do need one on a trip. So it really depends on the circumstances, and it's a good idea for the CSE and the Section 504 team to determine, depending on if the student has an IEP or a Section 504 plan, to determine what those accommodations are. There are a couple of circumstances where we don't have to accommodate for these extracurricular activities. One is if the accommodation fundamentally alters the nature of the activity. So Jeff always uses the example, if a parent says, my child needs a 5th base in the game of baseball, that would because of their disability, that would fundamentally alter the nature of that activity. We wouldn't have to do that. Baseball has 4 bases. That's like the only sports reference I can make. So we wouldn't have to put in a fifth base for baseball. The other situation is if the accommodation would cause an undue burden for these extracurricular activities on the district. Now, we have done extensive research. Andrew can attest to this. He has done extensive research for me over the years on what would be considered an undue burden. And our conclusions are cost and inability to find personnel are likely not considered to be valid undue burdens. So although they are truly burdens and truly difficult for districts, those likely would not be considered a valid undue burden if a parent were to initiate, for example, a lawsuit against the district on the grounds of disability discrimination. So again, another reason that it's a good idea to plan ahead. If you go to the next slide, please. Now, if we determine that a child cannot be accommodated, it's a good idea for that to come through the CSE or Section 504 team and for them to explicitly determine that there are no accommodations available that would enable the child to meaningfully participate. That's risky to do, just so you know. This should be a very rare circumstance. We should err on the side of accommodating and determining what the child needs to accommodate. But that determination should come through them, one of those teams. If a child is going on a field trip or an overnight trip and say they need nursing support or something like that, and if a parent volunteers to go, their parent, and says that they will take care of that, that gives us a nice out where I think we should probably take them up on that, because the parent can take care of those needs, but we cannot require it. We cannot tell a parent, if you don't come in here and take care of your child's medical needs on this trip, your child cannot come. That could be considered discrimination on its face. So if a parent's willing to do it and work with us, I think that's great. It makes it easier for us. We don't have to find somebody to address that, but we cannot require that. And we also can't charge more for that student if they need those accommodations. We have a question. Are the slides going to be available? Yes, you'll receive all the slides in a recording by email after this. What is the responsibility of an aide during an overnight trip, just for the educational activity or the entire time? The entire time. Whenever the student would need aide support, the district is required to provide that aide support for the student. And including in the hotel room. If the child needs an aide in the hotel room, then we would have to figure out a way to accommodate that. Some ideas we've come up with are an adjoining room or a suite maybe, to still give the child some privacy while there's adult support. Those are all things for the CSE or the 504 team to identify, but just because a child's in a hotel room does not give the district, does not relieve the district of its obligation to accommodate.
Okay, OHI. So we know there are 13 classification categories under the IDA. OHI is, of course, one of them. This is a pretty common one. If we could just jump ahead to the next slide, actually, because this is probably the most interesting thing about this topic is that, this is some years ago, I'm sure none of you are surprised by this, but in 2020, this was the third most common category of classification for students with disabilities, trailing learning disability and speech language impairment. So this is a very common pathway toward an IEP. And we can go back to the first slide. And so as we'll talk about, this is, without reading the definition word for word, this is generally, the ADHD pathway. We have a lot more diagnoses of ADHD these days, of course. Many reasons for that, but this is the pathway by which those kids come in to an IEP. So, just for the sake of being thorough, OHI defined as having limited strength, vitality, or alertness, including a heightened alertness to environmental stimuli that results in limited alertness to the educational environment. And that limited alertness is due to a chronic or acute health problems. And there's, a series of them. And one of those is ADHD, but it could be, epilepsy, leukemia, any type of condition that results in limited alertness to the educational environment, but also adversely affects the student's educational performance. So if we're going back to OHI, how common it is, sometimes, a lot of times, maybe this is used as sort of a catch-all, For kids who may have a certain diagnosis, it's not an automatic pathway just because you're diagnosed with one of these, acute disorders or illnesses or conditions. So the condition and the adverse effect must be connected. So to put it another way, let's say you have a chronic condition plus limited alertness plus poor grades. That's a pretty good sign that the student might be eligible, but it's not automatic. So the eligibility is there if the condition is causing the performance issues. So it's a little like the learning disability, analysis. Like, okay, what's really causing the gap? Very likely, I don't even want to say that necessarily, but a lot of times it will be the result of the condition, but not always. So just something to keep in mind. Adversely affects a student's educational performance. So just affects means it's currently happening. It's not could happen in the future or used to happen. It means the adverse effect is happening now. So this comes up maybe when a parent may be resistant to declassification. It might be very hard to convince that parent that the student who still has epilepsy, for example, that their student is no longer eligible for an IEP. That can be a difficult conversation, but adversely affects means currently adversely affects.
We have a question on that. What if we do not have an official diagnosis, just characteristics and it's impacting their progress? Wondering for both classification and consideration for 504. So none of the 13 special education classifications and 504, they do not legally require a diagnosis for eligibility for either. So you don't need a diagnosis for OHI classification or any classification, and you don't need a diagnosis for 504 eligibility. It's up to the district's evaluation to determine if the definitional criteria of a specific classification are met for a student, or if the 504 eligibility criteria, which is a physical or mental impairment that substantially limits a major life activity, is met. If there is a diagnosis, then great, we should consider that. It doesn't automatically mean a student is eligible. We cannot require parents to give us a diagnosis to determine eligibility. That would violate our obligation to provide a free, appropriate public education. It's not free. And it would violate our child find obligation, which is to identify, locate, and evaluate all students with suspected disabilities. So we can't require it. If they give it to us, great, we should consider it. It may help with the decision or not. If our team thinks a diagnosis is necessary to get there, which again, it's not legally required, then it's ultimately up to our team to obtain that diagnosis as part of our evaluation.
Okay, up next is parent counseling and training. So the goal and purpose of parent counseling and training is for the district to assist parents in understanding their child's special needs. It also can include providing parents with information about child development as it's relevant to their specific child, and helping parents acquire necessary skills that are going to allow them to support the implementation of their child's IEP. So one of the goals of providing parent counseling and training is for the parents to be able to be sort of active participants in the district's support of the student so they can understand their students' needs and the way that the IEP is designed to support those needs. It's not required or necessary for all parents of students with IEPs. There are a few scenarios in which it is required, which are on the next slide, including if a student is classified with autism. But aside from when it is legally required, it's within the CSE's discretion to determine what parents need to receive parent counseling and training. Similarly, there are no minimum requirements in terms of the frequency, the duration, or the type of counseling or training. These decisions are within the CSE's discretion as well. So the CSE has the ability to determine how frequently the counseling and training takes place. Sometimes it's quarterly, sometimes it's more frequent than that. It just depends on what the CSE determines the student needs. So I mentioned there are a few instances when parent counseling and training is legally required. One of those instances is for parents of students with autism. So if we have a student who's classified with autism, parent counseling and training has to be provided and needs to be on that student's IEP. And then the other instance is parents of students who are placed in a 611, an 811, or a 1213 special class. And this is coming directly out of Part 200 of the regulations, which tells us very clearly that if we have a student who is classified with autism or a student who, regardless of classification, is placed in a 611, 811, or 1213, we have to have parent counseling and training provided. And we want that to be included on the student's IEP so that if we do go to due process, we can demonstrate not only that it was on the IEP, but ideally we want to include some documentation of how we provided that counseling and training and what that looked like.
Okay. It was hard to come.
I'm sorry, we had a question. So I believe it was related to parent counseling and training. What if parents decline? There is no ability for parents to decline in a CSE's recommendation for an IEP. Obviously, we can't require parents to participate in parent counseling and training. I would recommend that it still goes on the IEP and that we just document that we offered it and that the parents are not participating.
Okay, let's go on to Q. It was hard to come up with a topic for Q, but we did quarterly IEP progress reports. So we all know where the schools should monitor and track a student's progress towards his annual IEP goals. However, they must also report this progress to the student's parents. And more specifically, this is what it says under the regs, that the IEP shall identify when periodic reports on the progress the student is making toward the annual goals will be provided to the student's parents. And to give some examples, such as through quarterly or other periodic reports. There is like a myth that it has to be as frequent as gen ed students. I actually thought that was the rule, but it's not exactly what it says. I think it would be a bad idea to report progress less frequently than gen ed students. So I think it's a good guiding rule that if the gen ed kids get report cards quarterly, then we should be reporting IEP progress on the same frequency. Failure to provide reports in accordance with the schedule determined by the CSE could result in a FAPE denial. So this is a big deal. Again, I rarely see it less than a quarter. I guess if your district gives report cards on or triennially, you could do that here. I would suggest stick with the quarterly. It seems to be working. And make sure they're sent out to the parents, make sure they're accurate. And it all actually starts in the CSE meeting. Develop goals that are measurable and can be easily tracked through data. Get you good data, send them out to the parents on the schedule set forth in the IEP, and you will be all set.
Reading. I'm getting a lot of good topics today. I'm really enjoying it. And it's just lucky because we just went in order alphabetically. So reading instruction historically has been a big one for due process complaints. There's been a little bit of a slowdown, but we're still getting a lot of due process complaints on reading instruction. And a lot of districts are unfamiliar with the requirements for specially designed reading instruction. It is support that can go on an IEP and that absolutely should be on an IEP for a student who has disability-related needs to read related to reading. If a student has a reading disability, we absolutely have to have some type of specially designed instruction on the IEP, but there's other student disabilities that might still require that. Specialized reading can be implemented through a certified reading teacher or through a certified special education teacher. There's no requirement that the person holds special certifications and like Orton Gillingham or Wilson. A lot of times parents will really advocate for that. But New York State assumes that if the person is properly certified as a reading teacher or a special education teacher, that they are qualified to implement and deliver specialized reading. And specialized reading can also be provided in a variety of special education settings. It could be consultant teacher services, resource rooms, special class, related services. Basically, anything on the continuum can provide specialized reading. You don't have to have a specialized reading group listed on the IEP. You can provide specialized reading in other ways. You can have a specialized reading group on the IEP. That's permissible. But you can provide specialized reading without that. You can do it in other ways as well. Next slide, please. It's really the goals that drive the service. So if we have very specific IEP goals that address reading, and if we have some kind of program or service on the IEP where those goals are going to be addressed, that is specialized reading. There may be students with more significant reading disabilities where we put maybe one-on-one reading instruction on the IEP. That is permissible. Or maybe a small group reading instruction on the IEP. That's permissible. But what's most important is that we have very specific measurable goals and a program or service that will address those goals on the IEP. We do not need to put on a specific methodology for specialized reading. So sometimes parents really want it to say Wilson or Orton-Gillingham or something else. We're not required to put methodology on the IEP. The goals drive the instruction. So sometimes parents of students with dyslexia want an Orton-Gillingham type of approach. And Orton-Gillingham really addresses things that we see in dyslexia, things like encoding, decoding, and fluency. So if the student does have needs in those three areas, we should have at least one goal in each of those three areas. And that would mean that the teacher would have to implement some kind of methodology that would be able to address those goals. But we don't have to put on the IEP that it's Orton-Gillingham unless everybody across the CSE table agrees that that is the only methodology that could possibly work for the student. Nothing else would work. That's the exception. I have never, I've been doing this and for almost 20 years now between being a CSE chair and an attorney. I have never actually seen that be the situation where there's only one methodology that would ever work for a student for anything, for ABA, for reading, right? I haven't, but arguably that could be the situation. In the absence of that, we don't have to put the methodology on the IEP. The goals drive the instruction and the teacher has the authority to determine what methods they're going to use to address those goals. Okay, I'm just checking to see if I got everything there. We should consider all of the parents' requests. When they bring this up, we should have a discussion about that. But again, if we feel confident that our goals address the students' needs and we have a program or service to address that, and if we have progress monitoring data showing that the student's making meaningful progress, appropriate progress, then that would be defensible. Next slide, please.
Okay, S is for surrogate parent. So this kind of ties back to the very first slide, actually, that Jeff was talking about for the age of majority. Not always, but that's probably the most common. So this is certainly a rare case, but it does come up. So we wanted to put it in here. So the takeaway is, like, a student must always have a parent during the CSE process. So going back to that age of majority that Jeff was talking about. So in some cases, we might need to assign an individual to step into that role because we don't know where the parent is, or they're not around. The student might be an unaccompanied homeless youth. So in that case, we actually have to appoint a person to step into the role as parent, because we cannot have, like as Jeff said, an 18-year-old, signing off on certain consents. So let's go back to when we would appoint that. So a couple of situations. So as I mentioned, the parents or guardians are not known. We can't find them after we don't know where their whereabouts after we've looked for them. We don't know where they are. The student is an unaccompanied homeless youth, as I mentioned, a ward of the state, which means they're in the custody, they're in the custody and guardianship of the state, essentially, a state agency, or the rights of the parent have been subrogated by a judge. So in those situations, here's one example. So we have perhaps an 18-year-old who's an unaccompanied homeless youth, and there's no parent. We don't know where they are. So the 18-year-old can't sign off on their own, on their own programming. So we have to appoint a surrogate parent. So the regs, there's very detailed regs. We could go into a lot of different scenarios. Who is a parent, who meets the definition of a parent. It's a little bit beyond, the scope of this for today. But it's in the regs. But, one other thing to know is that each school district is actually required to maintain a list of individuals willing to serve as a surrogate parent. So it's not necessarily just go out and find somebody. You have to maintain a list of people who are willing to serve in that role. And there's different eligibility criteria. So, for example, you can't be an employee of the district, you can't be an employee of, state ed. There can't be any conflicts of interest with the student's interests. So there are certain things that render someone eligible or ineligible. But the takeaway is that just know this is a situation that can arise. It is rare, but there must always be a parent during the CSE process.
Okay, Title IX, oft neglected in the world of K through 12, but we are required to follow it. Certainly all of our public schools, and in most cases our private schools as well. So Title IX applies to schools as well as local and state education agencies and other institutions that receive any federal financial assistance. And it prohibits discrimination on the basis of sex. And what we know from regulations and various guidance documents is that students are protected from sexual harassment, including sexual violence or gender-based harassment under Title IX. So if a student raises a Title IX complaint against a student who has a disability, then the school has to balance its obligations both under Title IX as well as the IDEA or Section 504. So ideally, we want these processes to be talking to one another. We want to make sure that if a student who has a disability has been named as a respondent in a Title IX investigation, that the CSE is involved and aware of that. So the most relevant obligations and protections under the IDEA and Section 504 are that a student with a disability is entitled to a manifestation determination review meeting before that student is subjected to a disciplinary change in placement, more than 10 school days. And only the CSE or the Section 504 team can recommend a change of placement for a student with a disability. So the Title IX coordinator or deputy Title IX coordinator is not able to unilaterally recommend a change of placement for a student with a disability, even if that student is involved in a Title IX complaint. Sometimes a K through 12 public school may wish to permanently remove a student from school as an appropriate supportive measure under Title IX. If that student has an IEP or a 504 plan, then that student is again entitled to a manifestation determination review meeting before that removal can be unilaterally imposed by the school. So if the manifestation determination review team finds that there is a nexus between that student's misconduct and the student's disability, then the school could consider placing that student in an IAES, an interim alternative educational setting, for up to 45 school days, but only if the very high standard for an interim placement is met. And we know from numerous commissioners' decisions that the standard for serious bodily injury and other reasons to be in an interim placement is a very high standard and can be difficult to meet. So the same holds true for a temporary emergency removal under Title IX. The Department of Ed commentary for the 2024 regulations, in fact, expressly states that the rules for emergency removals don't affect a student with a disability's right to have a manifestation determination review meeting.
Okay. U is for unnecessary psychological evaluation. So we all know, as a general rule, a psychological evaluation should be included in a student with a disability's initial evaluation and subsequent reevaluations. It's a key piece. There is, however, an exception to this rule. A school psychologist may determine that a psychological evaluation is unnecessary. This determination must be based upon and substantiated by an assessment conducted by the evaluation. So you need an assessment to determine the evaluation is not necessary. Whenever a school psychologist determines that a psychological evaluation is unnecessary, the psychologist shall prepare a written report of such assessment, including a statement of the reasons why the evaluation is unnecessary, and that shall be reviewed by the CSE. And this applies to both initial evals and re-evals. Now you see why it's probably easier just to do the eval. I wonder if this might, I don't see this come up very often, either done appropriately with the actual report. I see circumstances where they don't do, and a psychologist doesn't do a formal evaluation, and they'll explain it at the meeting. But keep in mind that there is an obligation to document the purposes for that decision. And of course, the parent has to be aware of that at the meeting, and that's something that can be challenged by the parent if need be. So again, it's required, but there are exceptions, and you have to document why we determined in this instance it's not necessary.
I would just say it's always more defensible to get more data. So there's really no downside to doing the evaluation. It doesn't mean that you have to always give a full cognitive and achievement necessarily. I think achievement can be helpful. But if you have a child who's 12 who's had 3 cognitive assessments and they're all in the average range, maybe you don't need to give a cognitive this time, but it's still more defensible, in my opinion, to do an evaluation and to assess at least in the areas of the student's disability. All right, I have a very quick one. Video conferencing for impartial hearings. The regulations allow for impartial hearings to take place by video conference, but only in specific circumstances. 1 is if there's a declared state of emergency, and 2 is with the consent of the parent. So in the absence of one of those factors, the hearing has to be in person. And you'll see hearing officers will ask if the parent consents to holding the hearing by video conference. And most circumstances they do. Most of them are by video conference these days. But if the parent does not consent and if it's not an emergency, then it would have to be in person.
Was fast.
No. And Andrew, I prefer video conference hearings. I find the process to go more efficient. It's less stressful, costs less because no travel fees, more flexibility for scheduling. So I think it's a good thing.
Yes, I agree.
Okay, W, withdrawal of consent for special education services. So a parent can withdraw, after initially providing education services, a parent can withdraw their consent at any time. It's their right as the decision maker to do that. And we can't, just like we can't use due process procedures to override the refusal to provide consent for initial services, can't use due process procedures to override it. We might think it's a bad decision, might not agree with it, but that's the parent's right. Now, the parent must withdraw or revoke consent in writing, has to be in writing. And, we can't withdraw consent for some, but not all services in the IEP. It's not a menu that you can pick and choose from. So it's you're revoking consent for all, or you're not revoking consent. So now, before you stop implementing the IEP, we have to provide the parent with prior written notice explaining the consequences of their decision to withdraw consent, which means you have to explain that the special education services are going to stop, and that the student is not going to have the same protections that they once did as a student with a disability. So, really this means the manifestation determination review. Those rights go away once a student has, when the parent revokes consent, they're considered a general education student again. They can be disciplined the same as any other general ed student. So we have to provide that prior written notice before we stop implementing the services in the student's IEP. What happens if it's possible. Now, let me back up. So now revoking consent doesn't alter the student's eligibility for services necessarily. So there could be a situation where they revoke consent and then, they subsequently ask for another initial evaluation. So if they revoke consent and they refer the student back to the CSE, that would be treated as an initial evaluation. Now, another little thing that might come up from time to time is, they revoke consent for an IEP, but they want a 504 plan. So that's a tricky situation. Now, the OCR issued a letter, way back in the 90s, 96, that rejecting IEDA services amounts to a rejection of services under Section 504. So I think there's some debate in courts along those lines. Perhaps not in our circuit, but that's generally the position we take. Also, is if you reject an IEP, you're also rejecting a 504 plan.
Right. The only exception, and there's some case law on this, if the student had two disabilities, like an educational disability and a medical disability, let's say student with autism and diabetes, and they revoke consent, it would be okay to create a 504 plan just for the medical issue. But people have to be careful. Like if you have an ED student with an IEP and then they revoke and they ask for a 504, they're going to have nexus rights. And so before you gradually, just the kindness of your hearts, give that away, if you might not have to, there's going to be consequences down the line on that. So definitely talk to us before you make that decision.
Okay, X is for xenial. I use this word all the time, and luckily now you can too. And for those of you who are fans of the Scripps spelling bee, the language of origin of xenial is Greek. So the word xenial is defined as relating to hospitality and friendliness between guests and hosts. And it's applicable to CSE meetings because we know that sometimes tensions run high. We have a particularly tough CSE meeting. But what we want to aim for is a xenial meeting, because those are less likely, ideally, to result in complaints and litigation. And another sort of piece of advice that we often give is try not to take it personally if things get sort of heated during a CSE meeting. But the more that we can just sort of maintain an environment of respect, make sure that the parent and their advocate or attorney are being heard, the better it's going to be for everybody involved.
Okay. All right, we're almost done. Why? Yearly CSE meetings. So we all know that after a student is classified, a student with the CSE is required to convene annually. So the regulations have been interpreted and enforced in such a way so that the students' annual review meetings are expected to be conducted within 365 days of each other, as opposed to once in a school year. Now you get some strange outcomes because some schools do anniversary dates and some schools don't. So those with if you just do them all in the spring and they're going to start in September anyway, the actual date of the meeting doesn't really matter. But the rules are what they are. They say what they say, and they've been interpreted in such a way so that if you don't meet within 365 days of your last annual review, you could be found out of compliance. So just keep that in mind. And obviously, the primary purpose of the CSE annual review meeting is to determine whether the annual goals are being achieved. So I think theoretically that pressures us to meet within that 365-day deadline. Years ago, there was more debate about this practice. Now, through strict enforcement from CEQA, this is less of an issue, but we wanted to include it anyway just to remind everyone what the rule says. And on to the last one.
Zero tolerance policies. I'm going to be quick. So there are some zero tolerance policies out there. If a student engages in a certain behavior, there's zero tolerance, automatically a certain period of suspension for that student. But that does not supersede any rights a student has in the manifestation process. So that manifestation still has to happen if we're looking at a long-term suspension. And if a connection is found, then the student's entitled to return to school. Unless either the parent and the district agree through the student's BIP to change the student's placement, which is a strange caveat in Part 201 of the regs, or if the student's misconduct involves serious bodily injury, weapons, or drugs. In that situation, the superintendent can order the student into an IAES for up to 45 school days. But in the absence of that, if a connection is found, even if there's a zero tolerance policy, the student is still entitled to all of those protections under manifestation. I think you're muted, Jeff.
Yep. How's that? We did it A through Z, 26 points. I think we went through most of the questions. Thanks to everybody for staying to the end. We're right on schedule. Any follow-up questions, feel free to reach out to any of us. Any suggestions for future presentation topics, let us know. And we will see you next in early May for our special education update. We'll be in person in Rochester and Buffalo, and we will also be accessible remotely as well so that everyone can access. Thank you, everybody. Have a wonderful day. Stay warm, and we'll see you at the next one.